In just about 30 seconds, something happened that left Justice Thomas completely speechless. It sent shockwaves throughout the judicial community and became the most watched legislative interaction of the year. This moment not only astonished legal experts but also changed how America views qualifications for good. It was a clear reminder not to underestimate someone who's fought their way to the top. Before we look at what Congresswoman Crockett did next, something that even took Thomas's supporters by surprise, don't forget to hit that like button and subscribe. This story illustrates the clash of overconfidence with solid preparation, and it's likely to be dissected in law schools for years to come. Trust me, you won't want to overlook the moment everything changed. It's essential viewing for anyone who feels underestimated. To grasp why this event went viral and shifted so many opinions, you've got to know the background. Justice Clarence Thomas wasn't just any Supreme Court justice, he was the longest-serving member, with more than 30 years under his belt since his controversial confirmation in 1991. Known for his conservative views and occasional pointed questions during hearings, Thomas was someone who typically dismissed legal perspectives that didn't fit his originalist stance. On the other hand, Congresswoman Jasmine Crockett represented a fresh wave of lawmakers. Before her time in Congress, she made a name for herself as a civil rights lawyer, working on cases that affected everyday Americans, while Thomas has always navigated the upper echelons of Washington. The hearing that brought them all together was supposed to be just another routine event. The House Judiciary Committee invited Thomas to discuss ethics reforms for the Supreme Court, especially given the controversies around unreported gifts to judges. No one thought there would be a personal clash, but it turned out to be a different story. The tension arose from a deep divide. Thomas represented the established legal hierarchy, while Crockett brought a practical, results-driven perspective that often gets overlooked by those in elite circles. Just weeks earlier, Crockett had remarked in an interview, "I've seen how society equates credentials with ability, often mistaking where someone studied for what they've achieved." Those words were spot on. Right from the beginning, you could feel the tension in the hearing room. When it was Crockett's turn to ask questions, people noticed Thomas's subtle change. He stiffened slightly and wore a faintly dismissive expression, a familiar sign for those from less privileged backgrounds that said, "You don't belong here." Ever experienced that look when walking into a room? Share your thoughts below if you've ever felt judged because of your background before you even had a chance to speak. Meanwhile, the room was quietly buzzing as Thomas fiddled with his microphone. C-SPAN cameras were capturing the packed gallery filled with legal analysts, journalists, and aides who were all leaning forward in anticipation. The chairman's gavel cut through the silence as he announced, "The gentlewoman from Texas has 5 minutes." Crockett started off with a calm, precise approach. "Justice Thomas, I appreciate you being here. I'd like to hear your thoughts on the emoluments clause in relation to judicial ethics." Thomas nodded slightly, maintaining a neutral but somewhat distant demeanor. "I'm quite familiar with the clause, Congresswoman," he replied. "I'm sure you are," Crockett said politely, "especially since you cited it a lot in your Howell versus Department of Interior concurrence." She quoted specific excerpts from his opinions word for word, with page numbers memorized, revealing her thorough preparation. Thomas's expression changed a bit, hinting at surprise. This wasn't the typical superficial questioning he was used to. "In that opinion," she continued, "you mentioned that public officials need to steer clear of even the appearance of financial conflicts. Yet your recent comments to the Senate indicated that justices should be subject to fewer disclosure requirements than other officials. Can you explain this?" Thomas cleared his throat. "You're conflating two distinct legal standards, Congresswoman. Am I?" Crockett shot back immediately. "On page 47 of your Howell concurrence, you connected those standards, stating, 'The constitutional duty for all federal officers applies strongly to those in judicial roles.' Those are your own words, Justice Thomas." The cameras picked up a brief moment of recognition in his eyes. She had quoted him accurately. Their back and forth heated up for about 3 minutes. Crockett pointed out the inconsistencies between Thomas's writings and his recent comments on judicial ethics. "We're talking about whether the standards you use for other officials should also apply to justices," she said. Thomas squirmed a bit, clearly uncomfortable. It wasn't every day a junior congresswoman dug into his own words. "These are complicated constitutional matters," he replied, his voice dripping with condescension, "that need a nuanced grasp of the separation of powers that might not be obvious to whom?" Crockett interrupted. "Congress members? Civil rights lawyers? Graduates from specific schools?" Her question lingered in the air, heavy with implication. Thomas narrowed his eyes, calculating his response. "Let's clarify things," he said, adopting the authoritative tone he'd used during oral arguments. "Interpreting the Constitution at this level requires specialized training. training. With all due respect, a Thurgood Marshall Law degree doesn't quite equip you for this sort of debate. The room quieted as he dismissed her credentials right there on the record. Committee members shot each other looks, and the chairman seemed taken aback. For a moment, Crockett paused, her expression betraying not anger but an acknowledgement, as if she had been anticipating this moment her whole career. Mr. Chairman, she said in a calm voice, I'd like to respond to Justice Thomas's comments about my qualifications. The chairman nodded. Go ahead. Turning her attention to Thomas, Crockett asked, before I get into your remarks about my education, can we touch on whether my analysis of your opinions is incorrect? I can pull up the citations if needed. It was a sharp move, pushing Thomas to either confirm her accuracy or risk being proved wrong by the records. He shifted uncomfortably. What I'm saying is that constitutional nuances need specific training. Which part of my analysis didn't reflect that nuance? She pressed. Was it my quote from your concurrence? The context of the emoluments clause? Or the contradictions in your positions? Thomas suddenly realized he had stepped into a trap. He had questioned her credentials instead of her argument. As you ponder that, Crockett continued, reaching for a folder, let's talk about your comments regarding my alma mater. People watching later described this as the moment that something remarkable started to unfold. Are you aware of Thurgood Marshall's constitutional law program? She asked. It actually requires 15 more credit hours than Yale's, and our grads pass the bar's constitutional law section at rates that are on par with those from prestigious schools. Thomas's jaw clenched. Since you questioned my qualifications, Crockett said, confidently flipping open her folder, let's take a closer look at my legal record instead of jumping to conclusions about my degree. The atmosphere was charged. Analysts were typing away at their keyboards. It felt like she was silently challenging. Have you ever been in my position, assessed by your education instead of your actual work? She addressed Justice Thomas directly, her tone unwavering. I understand you might have doubts about my ability to engage in constitutional debates, so here are some key points about my career. As she presented her documents, the cameras zoomed in on the official seals. After Thurgood Marshall, I argued Thompson versus Dallas Housing Authority in the Fifth Circuit. Are you familiar with that case? It was well known among legal experts as a pivotal ruling on housing discrimination. This case set new benchmarks for the Fair Housing Act regarding zoning, she elaborated, and it's been cited in 47 federal rulings while being taught at 23 law schools, including Yale and Harvard. The Fifth Circuit commended my constitutional analysis in the brief. Here's a copy of it. Thomas appeared taken aback. I also presented Rodriguez versus Texas Department of Public Safety before your court back in 2019, she said, displaying a Supreme Court document. That ruling, which you were part of, changed the way traffic stops are conducted. My brief was cited a dozen times. You described my response during oral arguments as thoughtfully articulated. Here's the transcript. Crockett continued, in the last 5 years, I've published 6 articles in constitutional law journals. My piece on originalism and the 14th Amendment even got cited in Justice Kagan's concurrence last term. Plus, I've got an invitation to the Harvard Law Review Symposium, which is only given to about 1% of scholars. Thomas tried to interrupt, but she firmly pressed on, I'm not finished. You publicly questioned my qualifications, so I owe it to the record to respond fully. Thomas, who's not used to being challenged, looked a bit uncomfortable. Back in 2020, I argued Williams versus Federal Bureau of Prisons, where we set the Eighth Amendment standards for healthcare. Justice Roberts even called my analysis insightful. And here's an amicus brief from Hernandez versus Arizona, which 23 professors signed to address Fourth Amendment border searches. The room fell silent, with the committee members completely captivated. I've taught constitutional law for 4 years, and my evaluations are in the top 5%. My dean highlighted my section on the Reconstruction Amendments, which I know you've looked into, Justice Thomas. She then pulled out a thicker document. In 2021, I received the American Bar Association's Excellence in Legal Reasoning Award for my work in constitutional issues, signed by 14 judges, including 3 of your colleagues. Crockett's final move was a killer. Last year at a judicial conference, you mentioned my article on administrative law and even called it compelling. So when you say my education didn't prepare me, were you not aware of my record, or did you just think my degree didn't count? The room fell silent. Thomas shifted uncomfortably, his earlier confidence evaporating. I might have jumped the gun on your background, he conceded, something you don't hear often from him. Crockett nodded and replied, thanks for that. Then she turned to the chairman and said, I've got time for one question about ethics. The chairman confirmed, 1 minute left. She looked back at Thomas. Doesn't the credibility of our justice system require us to judge arguments based on their merit rather than assumptions about who's presenting them? Thomas nodded slowly, good point. In less than 6 minutes, Crockett calmly laid bare the legal elitism at play. Social media lit up with clips captioned, This is how you challenge credential bias. What struck a chord the most? Her poise, the solid evidence, or Thomas realizing he was wrong? Have you ever proven a skeptic wrong? Things changed quickly after that. Clips went viral online, with analysts like Sarah Chen from Stanford saying it was a masterclass in dismantling credential elitism. Conservative Michael Wilson gave a nod to Crockett for her factual rebuttal. The hashtag credentials versus accomplishments started trending as law students and lawyers shared their own experiences of being underestimated. News outlets ran headlines like "Justice Challenged on Credential Bias." Morning shows got into debates over societal elitism, asking questions like, how many talents do we overlook just because someone doesn't have the right degree? Just 3 days later, Thomas made a rare statement, saying, "My exchange with Crockett made me rethink some career assumptions. Excellence in legal analysis can come from various paths. I regret implying otherwise." The effects were widespread. Law firms began recruiting at black and state law schools, the ABA kicked off an anti-bias initiative, and applications to Thurgood Marshall jumped by 32%. Crockett started getting offers to speak, professor roles, and even a Congressional Black Caucus Award. Students from her alma mater threw a watch party, with one person saying, "She showed us we don't have to just accept being underestimated." 6 months down the line, Thurgood Marshall set up the Jasmine Crockett Scholarship for Civil Rights Students, pointing to that exchange as a significant moment. Research showed that graduates from non-elite backgrounds often had strong practical skills, which led companies to rethink their hiring practices. A year later, Crockett shared her thoughts, saying, "That moment wasn't just about my achievements, it was for everyone who gets judged by where they come from, not what they can do. We should prioritize hard work over family background." Her message struck a chord and became a notable example of how facts can fight elitism. If you're curious whether challenging underestimations is worthwhile, just ask Thomas about his experience. This story really calls out the issue of judging people based on credentials. If you enjoyed it, don't forget to like and subscribe for more stories that show how substance beats pedigree. What part stood out to you the most? Crockett's statistics, her reference to the Supreme Court, or Thomas admitting defeat? Let us know in the comments.